Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the law and regulation knowledge area of CyBOK. The law and regulation knowledge area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Now let's look at the section on intellectual property. So let's begin with this. Intellectual property is simply a series of negative rights. The right to tell people to stop doing things. Owning intellectual property does not guarantee you any freedom to act. I often try to explain them as a series of red cards that you can show to others to say, stop doing this, or stop doing that, or stop doing the other. Within CyBOK, I've provided a very short catalog of the four most significant intellectual property rights that you're likely to run into as a cybersecurity practitioner. Copyright, obviously very important in the field of software. Patents, or even patents as we say, surprisingly important also in the field of software and very important for security product developers. Trademark, important to study especially if you're worried about domain names. And trade secret is an intellectual property right commonly relied upon in the cybersecurity field. I wanted to focus briefly on one issue that comes up with some regularity in cybersecurity, and that is the problem of reverse engineering. Now, reverse engineering historically has been accepted as normal behavior, and here we're talking about tearing a product down to try to figure out how it's been designed, how it's been put together, to try to figure out secret methodologies that a competitor hasn't want to publish. The reason that reverse engineering has been accepted as normal is that, after all, it doesn't invalidate any patent rights, it doesn't invalidate copyright protection. So if you pull a competitor's product to bits, and you discover a series of things, if that competitor has already taken out a patent, then there's nothing about your reverse engineering that reduces those rights. What successfully reverse engineering a product will do, however, is destroy any trade secret protection that might be inherently involved inside the product. This status quo was really challenged by changes to copyright law around the turn of the 21st century. And that was the time when policymakers around the world decided that they wanted to expand copyright law to prohibit people trying to circumvent copyright protection technology. That makes life very difficult for some researchers, and I've spoken about that in CyBOK. Particularly researchers who want to study things like digital rights management. You have to be extraordinarily careful because many of these provisions that prohibit circumvention of copyright protection technologies operate on a hair trigger, and you can find yourself very quickly crossing into liability and sometimes even criminal liability through what you might otherwise think of as legitimate research tasks. And finally, anyone involved in cryptography research will be familiar with the problem of trying to test what is otherwise a proprietary cryptographic algorithm. In other words, a cryptographic methodology that someone's trying to keep as a trade secret. And here I have linked to some descriptions of the Megamose crypto case, which went through the UK courts in the early 2010s. That case is extremely interesting because it talked about the problem of researchers who had reverse engineered a product in an effort to pull out the proprietary cryptographic algorithm because they wanted to test the strength of the algorithm. Well, it turns out that what they reverse engineered might itself have been the results of a trade secret violation. At least that's what was alleged. And these researchers wanted to publish the results of their findings, and they found themselves in difficulty because the owner of the trade secret decided that they wanted to intervene and try to prohibit the publication in a manner that would violate their trade secret. You can read more about that. Let's turn briefly.